We all know that whistleblowers create many challenges for companies. One of them is the battle over who controls the attorney-client privilege. Recent cases have held that senior executives who report concerns or improprieties to the legal department can't use the fact that they squealed as a defense without the waiver of privilege from the corporation. This dynamic creates material issues for in-house counsel to navigate. Our next speaker, Lee Dolan, from the Washington office of Nixon Peabody, will discuss these issues as well as the practical considerations for dealing with them. Please welcome Lee.
Thank you, and good morning. Oh, thank you. I'll need that. So this morning we're going to tackle the thorny issue of whose privilege is it anyway? And this question has arisen and changed in the context of whistleblowers over time. Whistleblowers have changed the complexion of one of the oldest and most well-recognized privileges in the law, the attorney-client privilege. Whereas some privileges are deemed to be qualified privileges, privileges that can be invaded under certain limited circumstances, such as the work product doctrine or the deliberative process privilege, the attorney-client privilege is often considered to be an absolute privilege, meaning that it cannot be invaded. But before we get to the vortex of whistleblowers versus attorney-client privilege, I thought it might make sense just to do a quick refresher on attorney-client privilege and when it attaches. Attorney-client privilege surrounds communications between counsel and clients, and in some instances, consultants, and in some instances, prospective clients, that are rendered or sought or provided for the purpose of legal advice. And I often see in my practice clients who simply think that in sort of the paradigm example, well, if I slap my attorney's name on the CC line of an email that has nothing to do with seeking legal advice, that will make it a protected communication that is not discoverable. Now, I'm not going to answer that specific question today, but there is a very real issue around whether if the underlying substantive communication was not designed for the purpose of eliciting legal advice, that is actually an attorney-client privileged communication. And of course, the communication has to be communicated in a way that intends confidence, right? It cannot simply be blasted out in this room, for example, if somebody were to ask me for legal advice, because there's no air of confidence that surrounds that communication. So with that as a bit of a refresher, let's start taking a look at the next piece of the presentation, which is the anti-retaliation provisions that are cropping up in the law and in policy, particularly being promulgated in Washington, D.C. Dodd-Frank greatly expands whistleblower protections beyond Sarbanes-Oxley. What it holds is that no employer may discharge, demote, suspend, threaten, harass, directly or indirectly, or in any other manner discriminate against a whistleblower in the terms and conditions of employment because of any lawful act of the whistleblower in providing information to the SEC, or in initiating, testifying in, or assisting in any investigation or judicial action of the SEC based on that information, or in making disclosures that are required or protected under Sarbanes-Oxley. As I said, we have a federal policy that favors whistleblowers. Believe it or not, the Securities and Exchange Commission has created the Office of the Whistleblower and has promulgated a statement that indicates that the whistleblower program is designed to aid in the SEC's efforts to protect investors from those who violate the securities laws by encouraging people that are aware of misconduct and impropriety and illegality to come forward to the SEC so that the SEC can initiate prompt and effective action to prevent the problem. Under the SEC whistleblower program, Section 922 of Dodd-Frank created Section 21F of the 34 Act, and the implementing regulations provide that the Commission will pay an award to one or more whistleblowers who voluntarily provide information, and the information has to be original, that leads to the successful enforcement by the Commission or a federal court or an administrative action in which the Commission recovers at least $1 million in monetary sanctions. So what does this mean? In 2016, the SEC awarded $57 million to 13 whistleblowers, which brings the program total since its inception in 2011 to $111 million. But perhaps the more important statistic there is the trend, which is that 6 of the 10 largest ever amounts awarded were in 2016. By contrast, under the Federal False Claims Act, approximately $5 billion were recovered in fiscal year 2016 alone, and those are paid out in various percentages under the statute in accordance with a court order to the whistleblower. The percentages range from 15 to 20, sometimes even higher in terms of a recovery for the individual whistleblower. So there's obviously significant financial incentive for whistleblowers to come forward. So now let's talk a little bit about how the privilege that we talked about, the attorney-client privilege, meets with some of these federal policy and state policy considerations designed to ferret out illegality. We're going to talk specifically about the advice of counsel defense and using the privilege to prove retaliation. The first case, which I think is important, is the United States versus Wells Fargo Bank. In this case, the United States sued the bank and a bank executive under the FCA and FREA. The claims arose from residential mortgage loans insured by the government. The executive, who was named as a defendant in the case, asserted the advice of counsel defense. In other words, hey, look, everything that I did here, I did because my lawyer told me to do it, right? And in that circumstance, the advice of counsel defense would have provided absolute protection for the individual defendant if he had been able to prove the advice that he received and that his conduct was consistent with that advice. The bank chose not to assert advice of counsel defense, but refused to waive the attorney-client privilege. So what you have is a clash between the fundamental fairness and due process claims of the individual, who is essentially saying, I have an absolute constitutional right to present every defense that's available to me, against the long-standing, well-known attorney-client privilege doctrine. So it raises the question, is the right to present the advice of counsel defense sufficient to overcome the bank's privilege? And the Southern District of New York in 2015 answered that question by saying that the privilege wins. The court said that it recognizes that the result is arguably harsh in this particular case, as it may well deprive the executive of his best defense for liability for tens of millions of dollars. The court went on to say, it is the price that must be paid for society's commitment to the values underlying the attorney-client privilege. The court went on to describe the effect of creating a privilege with a number of loopholes, if you will, a number of exceptions, and decided that that would be essentially no protection and no privilege at all, and that it would be worth very little if that was what the attorney-client privilege was reduced to. The court was concerned with the history of the attorney-client privilege and not turning an absolute privilege into a qualified privilege with a number of exceptions. The court also was concerned about creating perverse incentives for whistleblowers to come forward and accuse employees of wrongdoing in the hopes that the employee would be able to convince his or her employer to waive the attorney-client privilege. So there were some policy considerations around that as well, but ultimately the court concluded that the attorney-client privilege was an absolute privilege that could not and should not be violated, even in this context. There are other cases in New York that reach the same result, and we've cited a couple of those here in our presentation materials. But let's turn for a moment to the other side of the country, where we have a very recent decision being handed down by the Northern District of California. In that decision, which is Wadler versus Bio-Rad, the plaintiff was Sanford Wadler, who became Bio-Rad's general counsel in 1989 and served in that capacity for 25 years. He was terminated by Bio-Rad in June 2013. He asserted that he was terminated because he was investigating potential violations under the Foreign Corrupt Practices Act in China committed by the company, and because he reported his concerns to the company's audit committee when he determined, at least in his view, that the company was not taking reasonable steps to investigate and remedy those violations. Predictably, the company had a different view and contended that it terminated him due to poor work performance and behavioral issues, including anger management problems within the in-house counsel's office. At a jury trial in February of this year in the Northern District of California, a jury awarded the general counsel nearly $11 million in damages, including $5 million in punitive damages and fees. The district court had previously rejected the argument that the general counsel was not a whistleblower because he had only reported internally and allowed claims to proceed under Dodd-Frank and Sarbanes-Oxley. In December of 2016, however, the trial court denied Bio-Rad's motion to exclude the use of privileged information in an offensive manner, holding in dicta that the federal common law of privilege applies, including Model Rule 1.6, and that Sarbanes-Oxley and the policies underlying it preempt California ethical rules and may prevent or allow for the use of attorney-client privileged communications and information in an offensive manner. So think about that for a second. All of a sudden, you're in a meeting with general counsel and other individuals, you're exchanging information, and you don't know whether or not ultimately the information that you are exchanging with general counsel for the purpose of legal advice can ultimately be used against the corporation. Procedurally, this case was interesting because this motion to exclude filed by Bio-Rad, at least in some practitioners' view, may have been a little suspect. And that's because it was filed on the eve of trial, and in a 41-page opinion by the district court, the very first two lines of the opinion described the motion to exclude filed by the company as seeking to exclude everything learned by the general counsel in his capacity as general counsel for the last 25 years, right? So the corporation, in its decision to try to exclude this on that basis, set what I believe to be a very, very high bar to try to achieve, excluding everything that general counsel had learned in the past 25 years. And as we've already talked about a little bit, certainly there were materials that the general counsel learned and was privy to over the course of 25 years in the company that were not privileged. But nonetheless, they took the position that everything that he had learned should be excluded. Ultimately, the court concluded that the Ninth Circuit envisions that there is some room for the use of privileged information, including the use of such information offensively to establish whistleblower retaliation claims under Sarbanes-Oxley. The background of that case, I think, is very interesting, and I'm not yet convinced that that case is as strong as this language appears for people who are looking for an opportunity to present attorney-client privilege information offensively. And the reason for that is because there was a substantial amount of discussion between plaintiff's counsel and defense counsel prior to the filing of any of the administrative complaints and ultimately the complaint in the district court, in which they agreed as to certain information that could be disclosed without violating attorney-client privilege. And in fact, in rendering its decision, the court concluded that there was a substantial amount of attorney-client privilege information that had been filed in the public record with no objection and no effort to seal that information made by the company. Now, in contrast, the U.S. Bank case that we talked about a few minutes ago, there the individual defendant had filed with the court a notice of intent to rely on the advice of counsel defense. And the court there said that in and of itself is not a waiver of the attorney-client privilege. But had the bank not timely objected to the use of such defense and the disclosure of the underlying privileged information in connection with it, the court in dicta said that could well have constituted a waiver of the attorney-client privilege. But the bank timely filed a notice of objection and moved for protective order in that case. So what do we make of all this as some takeaways? The practical takeaways here are that this is a minefield, right? This is an area that is very dangerous in the law right now for in-house counsel to deal with, because there is a very real possibility that the strictures surrounding attorney-client privilege and attorney-client privilege communications may change over time. This obviously can lead to significant internal corporate tension and may also result in the need to retain separate independent counsel to review these specific issues and to provide guidance to the corporation. With that, I thank you.